Hello and welcome to this BID event. That's Bail for Immigration Detainees, and this is Excessively Cruel: Detention, Deportation and Separated Families. Thanks everyone for turning up on this sunny afternoon. You have a wonderful panel to listen to and engage with today. First of all, we're going to have a short video from the actor Ace Ruele, who sadly couldn't be with us today, but has sent a video message. Then you will hear from three experts in the field of immigration and family reunion issues in particular, and family separation issues, I should say. We'll have Rudy Schulkind, who's a senior researcher and policy coordinator for BID. We'll hear from Sonali Naik QC, a hugely celebrated and experienced human rights and immigration Queen's Counsel. And finally from Dr. Melanie Griffiths from the University of Birmingham, and the author of Deportation and the Family. So we'll hear from each of them for about 10 minutes, and then there will be an opportunity for your questions, comments, and my favourite, which of course are comments very thinly disguised as questions. So do think about those points and queries as the first hour or so of the event takes place, and put them in the appropriate place on the question setting on your Zoom. So first of all, let's hear the message today from someone who's experiencing the cruelty, the excessive cruelty of this immigration system. Let's hear now from Ace Ruele.
Hi, welcome, Ace Ruele. Thank you very much for joining us today.
You know, again, I say thank you to you and everybody out there that's, trying to have some involvement in support in regards to my case. So thank you, really. Thank you very much. We're
really happy that you're able to join us. Okay, so I think to start off with, it would be really good if you could just introduce yourself, really, give us a bit of background about yourself and your struggle with the Home Office.
Okay, I hope y'all got like 10 minutes or so, because we're going to be here for a little while. But so my name is Ace Ruele, and that's my first and middle name. That's the names that I use professionally when I'm doing any form of public engagement or as an actor. And my main background, if we're talking career-wise, is that I'm a full-time actor. I work in the VFX part of the industry as a actor that specializes in motion capture. So, the stuff that you see Andy Serkis do for Planets of the Apes, and humans that run around in video games and you're moving the control pad and stuff. That's a lot of the stuff that I do. And I've done it for films, from Legend of Tarzan all the way to working on the recent Marvel Eternals, to video games like Planets of Yay, Dead Islands. I've got a long list, but we're not here for that. So that's what I do full time. And basically my whole situation with the Home Office that has come to light in the last month has come down to, there's a couple of main factors in my case. One, what people are kind of astounded by is that I was born and grown here. And two, there's a part between two court hearings where one thing was said and then another thing was said, even though the evidence was provided. And three, that the type of harassment that the Home Office has given to me in regards of, when I go through the story, you see the difference in time, and it's like, okay, why? I don't understand that. So to cut a long story short, I had a run-in with the Home Office because when I was 19, I'm 33 now, I ended up going to prison for robbery with imitation firearms. Imitation firearms being a plastic BB gun for robberies. And I got sentenced 8 years, and I served 4 years in prison and 5 months in a detention center. So this was from 2007 all the way to 2007 October to all the way to April 2012. And I'm just going to say the date so you guys can understand exactly where and why the homeless came in. So halfway through my sentence, or should I say a year before my sentence ended in 2010, I got a letter from my door, like August, September times. No, someone handed me a letter, should I say, and it read about being deported. Now, for me, I didn't really understand what was going on because in my whole mind, I thought I was, British or whatever. As a teenager, you just thought, what do you mean deport? Like, I was born and grown here. What are you on about? Obviously, I don't know about immigration. I don't know about law. I don't know about all of these things. So in my mind, I'm like, what do you mean? And obviously, it came to the fact that because my mum came here after 1983 and none of my parents were British, that made me an automatic Jamaican national. And, I had indefinite leave to remain, but I didn't have citizenship. But for me, I just thought I was just born and that's it, And I had a Jamaican passport. I just thought, oh, I got a Jamaican passport. Everyone's got a British one. I got one like my mother. So from 2010, I went to my first hearing in 2011 for deportation, and that got thrown out. Then the Home Office appealed in 2012. That got thrown out. Then I came out of prison. Detention center. So I was originally supposed to be released from November 2011, but the additional months made me have to stay inside in a detention center. I think I was at Brook House, and that was until April. So I've come out now. Had my second to last hearing. Home Office appealed, and it wasn't until 2013 that was all the hearings that had been done. So I was on immigration bail that whole time when I came out. So I had to sign on, I think, every week or every 2 weeks. I can't remember. Or 1 month once. I can't remember. But 2013, out of prison for a year, Home Office finished, done. Finito. No more deportation case. 2.5 years later, after I decided to go to my MP to try sort out, what I have indefinite leave, but I don't have citizenship to Jamaica. So basically, I found out that even though I had a Jamaican passport, I didn't have citizenship to Jamaica because the way that they regulated things back in the 90s and before the 90s, you could have got a Jamaican passport through nationality through my mother. So for me, in order for me to get a Jamaican passport now, I've got to apply to be a citizen first, then apply to get the passport. So then I thought, okay, so if I'm not a Jamaican citizen, then that means I'm basically technically stateless. So maybe my MP can sort something out. I don't know what happened, but from my MP trying to do anything, or the people at the MP's office, Home Office came back to me. This is like 2.5 years later, talking about they want to revoke my indefinite leave to remain and put me on limited leave. Again, I really don't understand why they're doing this, because for me, it's just like, all right, now I've been out of prison for 3.5 years. Been out of prison for 3.5 years, never been arrested, never got in trouble, never done anything. I've been working. I had my child on the way. I had another one on the. I had my child born, and then I had another one on the way. I was working in film. I was working part-time as an acting facilitator for a theatre company. I was doing talks for the peer outreach team at the London Mayor's office, for different schools, for Hackney Council. I was doing things that I believe that you could use as an example of rehabilitating from prison. But anyway, Home Office decided what they wanted to do. And in 2016, I was at court. So now this is by the time I went back to court in 2016 for now my indefinite leaves to be revoked, I had finished my license. So, when you go to prison, you do half in and the rest on license. Finished my license, everything. So I'm fully clean, fully clear, everything. And the judge at that hearing said, he gives me credit because he can see that my life has changed in the sense of I've not reoffended. I show proof of work, show proof of charity work, show my family ties. My partner was there at the court, everything. So he said he cannot see, in his eyes, he cannot see the reason of revoking my indefinite leave when I cannot be removed from the country anyway, apart from you put me on limited leave just to apply more stress mentally and emotionally, and it being an extra expense. Because if I can't be removed And it's been like almost 4.5 years after my prison sentence. 2.5 years, after, 4.5 years after my deportation case, by the time I actually went back to court, it's just like, 3.5 years, why are you troubling me again? So he was in my favor. And then the Home Office appealed, of course. And then I went to court again. Now, when I went to this court, this judge had, I'm gonna be honest, and obviously this is only, people can only look at this like me being biased, but I had the sense from the judge that he wasn't going to be in my favor. I just had the sense from it, the way like he spoke, the way he came across. It wasn't like he was just going by non-judgmental and what's on paper. It's like he had his own intention. That's what I felt. And obviously what I felt was real because I lost that case. And there was a few factors of that case to why I lost it. But the ones that really are contradictory to the previous court is the fact that he said, one, I never showed suitable employment. Therefore, I had a financial incentive to reoffend. I don't understand how you saw that, because the last judge said that I provided large amount of documents that went unchallenged, from work, from charity work, from all of that. So what financial incentives are you talking about? Secondly, another thing he said was that I claim to have family ties with my one son. Bearing in mind, by this time, I had two boys. One was born in October 2014. The other one was born in December 2015. We're in court in November 2016. So I've had two children, but he only mentions one. And the one he mentions, which must be my oldest son, he has my child's date wrong by a year and a couple of days. So my child's born 2014 on the 11th. The judge said 2013 on the 9th. This was in his writing. So it's like, I don't understand, how do you think I'm claiming to have family ties when, first of all, I've got more than one kid, which the last judge said I supplied the birth certificates of my children. And also he says family ties, but my partner was there with me in court, the mother of my kids. So what do you mean I'm claiming to have family ties with my children? And, the Home Office gave me enough time to, show that but I didn't. Hold on. But again, the last judge said I provided all the documents. So, and then the last thing that he said that really was another thing that you have to kind of think about, where is this guy going with? Basically, when you have immigration on your case, which you guys may know, they ask you to write a letter. Write a letter of why we shouldn't do this to you. I don't get why they do it, because I don't think any letter that anyone's ever written has made them say we're not going to try to take the act against you. So wrote a letter, and in the letter, it also highlighted about, I feel that it must be some kind of conspiracy against black males, because you've left me alone for 2.5 years after my deportation case. You've left me alone. I can understand if you ended the deportation case and a month later tried to go for my indefinite leave. It makes sense. But you left me years alone, and I haven't caused any problems. And I'm born here as well. So, and I can't be removed. So in my young mind, I'm thinking, this must be got to do with my color and my skin as well. And the judge turned around and said, I wish I had it here so I could read it word for word. He turned around and said, because I made an allegation about conspiracies to destroy young black men, that I had not to come to terms with my offense and not taking the steps of no longer reoffending. So he's talking about a letter that you wrote, and that's the statement he made. And again, I can send this paperwork to anybody that wants to see my paperwork. This is what the judge said. And the maddest thing is about that situation is that argument wasn't even in my grounds of appeal. So the last judge read the same statement and said it's a serious allegation, but I can understand where he's coming from, but he did not try to make it a part of his grounds of appeal, which I didn't. It wasn't part of my argument my lawyer was saying. So if that judge recognized that, why are you then bringing up something that I didn't even make my grounds of appeals and it was just in a letter, and you're going to use that as one of your statements? So when you look at all of these things that he said, and there's other stuff as well, but then it's not contradicted to what was being provided in the documents, you have to ask yourself, did the courts do my paperwork, or was he racially biased? Because it just doesn't make any sense. So because of that, I lost my indefinite leave, tried to appeal, no appeal, courts would hear me. I wouldn't get no hearings. They were all refused. And so now I'm on basically limited leave, and being on limited leave means that in July, I got to pay $2,500 or whatever it cost to have another 2.5 years. And for me, it's just like, if you can't remove me, so technically you're just making me pay just so to get extra money out of me. You know, what happens if I can't pay? What happens? I become an overstay, and overstay is a criminal offense. And if I'm a criminal offense, you know, what happens then? You know, what can you now bring up deportation because now I've committed a criminal offense? So it's just like, for me, it's just that's where we are right now. And in regards to, you know, my story being out there and what I'm trying to achieve, it's just a thing more. I've been told by lawyers that, immigration lawyers, that this is no longer an immigration matter because all the appeals have been exhausted. So all my appeals have been exhausted. So there's technically nothing they can do. So it's more like a human rights way, you know, or if I can thoroughly prove that, you know, the judge made an error from what he said compared to the other one, then there might be something there. But what I'm trying to do with it being public now is hopefully have people that come from a particular platform and have a particular form of influence as a, you know, politician or as an activist or anything, that can have some influence and some pressure onto the Home Office to look at this and like, this is a harassment. Like, Home Office could have looked at me as somebody that has come out of prison and completely gone 180, you know, and use it as an example. But instead they want to keep doing me over. So that's the kind of position that we're in now. And I hope that happens, as well as, you know, I feel like I want to do something in regards to the law being scrapped, because I don't believe anybody should be liable for deportation if you were born and grown here and you lived here your whole life. I don't get why. Like, why? Because the parents never done the correct paperwork. It doesn't matter what crime you commit. And yeah, you know, there's some really foul crimes, but that's what prison's for. You know, you commit a really foul crime, you stay in prison for almost the rest of your life. But being born and grown here, you should never be allowed for deportation. You shouldn't, because you can't deport someone to somewhere they never came from. So that means anyone could be subjected to that then if your parents are not English. And technically, how far back is the Home Office allowed to go? Because, you know, your parents might be here, but what about your grandparents? So yeah, that's where we are with the whole Home Office situation.
Well, thank you for sharing all of that with us. I wish that your story wasn't a really common one, but you've touched on so many things that we see really regularly at BID, and I think it's been really helpful having your account to give context to a lot of what else is going to be discussed at the event. Yeah, we're really sorry that you've had to go through all of that. One thing that I wanted to touch on really quickly, would you be able to talk a little bit about that? Did the Home Office consider the fact that you had children in the UK?
I don't think they cared, to be honest. Like, that's just being honest. I don't think they cared, because they knew I had a child. They knew everything. You know, they got a letter from my partner. They got a letter, like, you know, they don't care. They don't care. That's the fact. There's no if, buts, maybes. They don't care.
Yeah, I think that's really, I think we see examples of that all the time in terms of very little regard for the suffering caused to inflict these really kind of awful policies. I think that's probably everything that we want to cover from our side. So we just want to say a massive thank you very, very much for coming on here to share your story.
That's all right. It's no problem. Not a problem. Not a problem.
So that was Ace Ruele. Pretty horrific, but all too common story, unfortunately. For those who've just joined us, this is the BID, Bail for Immigration Detainees event, Excessively Cruel, Detention, Deportation and Separated Families. We've just heard from Ace, we've just heard that powerful testimony of being treated absolutely appallingly by the Home Office over some years. And now we're going to hear from the Research and Policy Coordinator of BID, that's Rudy Schulkind, who is the recent author of some new research into the impact of deportation on children and families in particular. Rudy.
Thanks very much, Shami. And yeah, thanks everyone for attending, especially in the sunshine. It's great to be here with such an amazing panel. I think this event comes at a really important time when the cruelty of the deportation system is increasingly coming to be recognised, and that's thanks in a large part to people like Ace coming forward. Yeah, so our research that we're launching today focuses specifically on the deportation system, and it's based on interviews with people facing deportation. But I want to just start by speaking a little bit about our deportation project and the legislative changes that preceded it before presenting our research. So I think a good place to start is the 2007 UK Borders Act, which introduced provisions for automatic deportation for any foreign national serving a criminal sentence of 12 months or longer. BID lobbied against that at the time on the grounds that, were later proven to be correct, that this would sweep up long-term British residents and people who were not British citizens, but who had, long-standing ties to the UK. And, the UK was the only country that they call home, but that they would then be swept up in these these cruel deportation measures. But the government argued that it was okay because people had the right to legal aid. And until 2013, they did, but all that changed with cuts to legal aid that removed immigration work from the scope of legal aid. And then that was followed by further changes brought in under the Immigration Act in 2014, which introduced additional hurdles that meant to succeed in deportation on the basis of your parental relationship in particular, it was necessary to show that deportation would be unduly harsh to the child. And what that means and how that's been interpreted by the courts is to mean excessively cruel. And so, in other words, UK law currently, it sanctions cruelty to children, provided that it's not excessive. And so around that time, around 2014, we were receiving a lot of letters and calls on our advice line from people, about bail and getting out of detention. But we saw the underlying deportation matter wasn't being dealt with. And lots of those people were being held post-sentence in prisons under immigration powers. And they didn't really understand what was happening to them or had no support or legal aid. And, like Ace, Ruele, like many of them thought they were British or may have had children in the UK. And so BID responded by setting up its Article 8 deportation project to provide legal advice and representation to people in that situation with strong ties to the UK. It's a really small project and it's nowhere near meeting the demand that's out there. And there's probably hundreds or thousands of people who came to the UK as children or who themselves have children here, but they can't access the help they need to challenge their deportation. So alongside that, we're also lobbying for changes to deportation law, and we carry out research and policy work to that effect. So the research we're launching today, through that we wanted to document the harm caused to family members through deportation, looking particularly at the entire family unit and children in particular, because something we felt is essentially a national scandal that's being overlooked. So last year we published a literature review looking at academic insights relating to the impact of forced parental separation in the context of imprisonment and deportation across different disciplines and in different countries. And unsurprisingly, the evidence overwhelmingly found that forced parental separation has a profound and permanent impact, potentially affecting every aspect of a child's life and development, and with effects that endure well into adulthood. Alongside that research, we also produced a self-help guide that unrepresented people could make use of in deportation appeals, although of course being forced to rely on generic evidence is far from ideal. And equally, the interviews that form the basis of the report we're releasing today were largely focused on the impact on children. And we found that, you know, these frequent and unpredictable periods of detention and dawn raids to enact that detention, and living with the constant threat of deportation alongside the hostile environment, this has, you know, huge impact on every aspect of family life and family stability and structure. And it was a huge source of practical and emotional difficulty. The lack of safeguards, in particular in the detention system, and the lack of judicial oversight of that system, means that family life can be brought to an abrupt end at any moment. And it's impossible to underestimate just how damaging that is for an experience for people to live with, you know, the shadow of detention looming over every part of their life. And the mental health consequences were really severe. And the people we spoke to in interviews reported their children being traumatized, developing anxiety, and, you know, crying constantly, withdrawing from everything, from school and hobbies, and suffering from loss of appetite, difficulty sleeping, and nightmares and self-harm. And, you know, some of them, you know, really, really serious symptoms. And a number of interviews reported that their children are now, you know, anxious every time there's a knock at their door or that their dad leaves their sight. And, you know, all of this, you know, extreme severe harm is quite stark contrast to the government's approach and the rigidity of the legislative framework in place. So the Home Office does in fact have a legal duty to promote and safeguard the welfare of children and to make the best interests of children a primary consideration in every decision. But in our experience, that is routinely disregarded. And what's more, the Home Office often makes use of, you know, disingenuous stock phrases to justify decisions to deport parents. So saying things like there's no threat to the child's well-being by the parent being deported, or you know, the child's emotional needs and care would be provided to them by their mother, or even that, you know, you can maintain the parental relationship from abroad via modern methods of communication such as telephone, email, or letter. So, you know, obviously quite disingenuous and not really displaying any real care for the, you know, the welfare of the child, it doesn't seem. And that's, you know, very much Ace Ruele, you know, he echoed that as well. And, you know, generally those statements, they're not based on any evidence. And at the same time, you know, the Home Office is quite aggressive in how it approaches these cases. Again, something Ace was referring to, and how, you know, in our interviews with people we spoke to, felt that Home Office was deliberately trying to kind of create immense stress and disrupt family life in whatever ways they could. But then, yeah, aside from that kind of the Home Office's approach and, you know, the institutional culture that creates it, there's also just this extremely rigid and inflexible and harsh legislative framework. So, you know, deportation is a permanent exile, and there's no room for rehabilitation within that. But at the same time, primary legislation states that the right to family and private life has to be balanced against the public interest in the deportation of foreign criminals. And like I mentioned, parents need to show that to avoid deportation, that they have to show that it would be unduly harsh. And that leaves many parents unable to win their cases because the threshold is so high. And, you know, considering this notion of the public interest, we feel that, you know, it's not in the public interest for children to be forced to grow up without a parent, particularly when you look at the long-term impacts of child development. It's, you know, it's actually quite detrimental to communities and to society as a whole. So that, you know, we think the starting point should surely be that a parent who is involved in the care of the child, who's living with the child and is providing, you know, emotional support that's essential for well-being and growth and development, that, you know, that parent being able to remain with the child should also be in the public interest. I also want to say something about barriers to accessing justice, because obviously deportation appellants, they're thrown into this, you know, really harsh and adversarial system, and they're against the Home Office's effectively limitless resources, but they don't even have access to legal aid. And you know, there's a number of other barriers that the people we interviewed face as well. So that's, from the immense complexity of immigration law and the cost of any private representation, particularly given that harsh deportation law means you now really need expert reports to evidence the harm caused to your child, and that will cost, you know, £1,000 or £2,000 generally. And then on top of that, there's the frequent and excessive use of detention, which, you know, not only is it an injustice and a deprivation of liberty, but it also creates all these practical barriers around you trying to prepare your case, particularly where detention takes place in a prison. And so, you know, generally we found through our interviews that this was a system that made it pretty much impossible to access a fair hearing. So overall, you know, the evidence we're presenting today in our research is, you know, presenting what we feel is a compelling case for an overhaul of the entire system, and showing how the harms caused by the deportation system, they're not reserved for the individuals targeted. They span many different areas of life over many years. They offer people no second chances, and often it's children who suffer the most. And it's really not clear what part of any of this broken system is in the public interest. And on top of that, you know, thousands is spent detaining people every year, often pointlessly or even unlawfully as part of that system. But I do want to end on a positive note. I think that's important. I think, so I want to look at around the last 2 charter flights to Jamaica, the incredible amount of support there was from commentators from across the political divide and among parliamentarians. And I think the conversations being had in those spaces would have seemed quite a long way off a few years ago. That momentum was thanks to many organisations doing campaigning and direct action, and the many people who have come into the public eye to tell their own personal stories of deportation. I think it's helped to show that most people facing deportation are integral parts of families and communities in the UK, and they consider the UK their home. I think this has really helped to kind of dispel this racist and ahistorical myth that's peddled by the government that people facing deportation are essentially, you know, visitors who've come to the UK and abused our hospitality, which is very often the argument. But yeah, there's a lot more that could be said, but I'm going to leave it there for now because we've got such a great panel.
Thank you so much, Rudy. There was so much to think about there, and for me in particular, I think your point about the importance of not destroying lives and breaking up families should be in the public interest part of the balance, as well as in the part of the equation that is about the individual's human rights. I thought that was a very compelling argument, and I will be very interested in what our next panelist has to say about that proposition in legal terms, as well as the rest of her presentation. And we're now going to hear from Sonali Naik QC, my learned friend, but also a very, very dear old friend, and a very, very celebrated practitioner in this field for about 28 years or something obscene like that. She'll forgive me. Forgive me suggesting that she's even more than 28 years old. But she is, because that's how it works. Sonali, let's hear your presentation, please.
Thanks very much. And I really thank you for that introduction. And I really echo what I've heard from Ace and from Rudy, really chime with what I want to say, and indeed certainly want to come to that question. My experience over the last 30 years in practice has shown that it's been increasingly difficult to succeed in a deportation case. But I think Rudy is absolutely right in a criminal deportation case that it became much harder after the 2007 UK Borders Act, and that was introducing the automatic deportation provisions because there was a sort of scandal. It was the Charles Clarke scandal where people who were potentially liable for deportation had never got into the system. So there was a reaction to that, which was let's go for auto deport. But there was a really important proviso there, which is unless it is a breach of the ECHR, unless it's a human rights breach, in which case you can't deport people. So on the face of the statute, it could have been workable. Rudy's identified the problems with it, which is that now in operational terms, it's very difficult for people to make out their cases. But also the evolution of how the law has been enacted has been, I think, misinterpreted at best. it may be possible that we don't need a change in the law, we just need a better interpretation of the law we have to make it real and effective. Because after the automatic deportation provisions in 2007, in 2009, the government enacted the duty to take account of best interests in relation to children in deportation cases, and that hadn't been in immigration cases generally, but that hadn't been part of our domestic law. It had always been something in the context of the UNCRC Convention on the Right of the Child. So that was an important threshold moment. And had we remained there, I think that there would have been possibilities of people winning cases as long as they did have access to legal aid to get their reports and so on. But as Rudy mentioned, the 2014 Immigration Act introduced this statutory public interest consideration, which is it is in the public interest to deport people, and unless it is unduly harsh on the partner or the qualifying child, i.e. a British citizen child or a child who'd been here in the UK for more than 7 years. Now, that has been interpreted, and that's only for people who are in what's called the medium category of offenders, which is those with a sentence of between 1 and 4 years. So those with a sentence of over 4 years, which is the situation that Ace found himself in, was that however long ago, which is that you then have to show very compelling circumstances over and above the unduly harsh test, and including that you have been faced very significant obstacles to integration in your country of origin. Of course, we've talked again heard from Ace about his country of origin being somewhere completely alien to him, and there are a number of cases that we've seen where people who've been born in the UK but who aren't British citizens have been faced with deportation. And that cannot be what Parliament intended when it was trying to scrabble around to deal with the Charles Clarke episode and to deal with the situation of people who'd come to the UK as adults and committed offences. That is certainly a whole different scenario. Importantly, and this is why I say that on the face of the statute book, there may be provisions that we can rely on. When the 2014 Act was introduced, it expressly said, and this is thanks to some activity in the Lords at the time, that the Act does not limit any duty imposed on the Secretary of State with regard to the duty to have regard to the welfare of children, the Section 55 duty as it's so called. That's a critical importance in my view, because it means that the procedural obligations, which is there the evidence in relation to children, the substantive obligations is, well, how will it affect them, have not been downgraded by Parliament, and nobody can properly say that they have been. And it's of interest to me that, as far as I can see, there hasn't been a case on that Section 71 of the Immigration Act 2014 about the importance of that. But coming back to the points that Rudy and Ace touched on, and that Shami specifically asked, we already have some really good authority from the Supreme Court on that point, which is that children need a family life in the way that adults do not. We're thankful to Baroness Hale and the late Lord Kerr for their fantastic jurisprudence on children's rights, which all courts need to be reminded of. Depriving a child, said Baroness Hale in HH, which was an extradition case, depriving a child of their family life is altogether more serious than depriving an adult of his. And although a child has a right to a family life and all that goes with it, she said there is also a strong public interest in ensuring that children are properly brought up. So we've got the authority. It's just not, in my view, being used by courts or prioritised by courts. She said children need a family life in the way that adults don't. They have to be fed, clothed, washed, supervised, taught, and above all loved if they're to grow up to be the properly functioning members of society, which we need them to be, and their emotional needs can only be fully met within a functioning family. So for those cases where we have that evidence, or where you need to get that evidence, and I think Rudy is absolutely right that a lot of people struggle because they don't get that evidence, that's the framework that should allow people to succeed. And indeed, Baroness Hale, in another deportation case called McLuth, in Baroness Hale and Lord Kerr in McLuth in 2016, identified that children must be recognised as rights holders in their own right, and not just as adjuncts to other people's rights, and that their best interests must be considered as a primary consideration, we know, but also separately from those of the adults involved and from the public interest. So we can see that there is law that supports some of the propositions that we want to make here, and we want to use in a sort of effective and individual cases in the tribunals. It's just that there seems to have been an evolution of thinking in the tribunals and the higher courts, that somehow you can't succeed in deportation cases, and that Parliament did not intend this cohort of persons to succeed, and that's, in my view, just simply wrong. So I had the fortune or misfortune to be in the Supreme Court decision in KO, Nigeria, where the court tried to interpret that question of what unduly harsh meant. And Lord Carnwath said, well, there seems to be a suggestion that means that there's an implied level of harshness that is due. But that's wrong. It must be wrong, because it is only concerned, he accepted that it was only concerned with the impact on the child, and not balancing it, for example, against the weight of the nature and degree of the offending. And so he said, and this is, I think, one of the really problematic lines in that judgment, one is looking for a degree of harshness going beyond what would necessarily be involved with any child faced with the deportation of a parent. And that's the phrase that a lot of the courts have got stuck on, and thought, well, we have to look for something more, something compelling. You have to be of, an illness or a family sort of emergency situation, rather than something that is more commonplace. And more recently, and this is where there's a sort of glimmer of hope in the cases that we do have, that the Court of Appeal, and importantly, and this is where I think we need to do some learning from the family courts, because what we have is, if a child was being taken away from its parents in a family court proceeding, there would be, the father would be represented, the mother would be represented, the child would be represented, the local authority who was doing the intervention would be represented, and there may be another independent party as well. They'd all be looking at the issue of the question of best interest of the child in that context. You don't get anything like that in the deportation context. What is the Home Office say that the duty is discharged by them notifying the parent that they're going to be deported, and then expecting them to produce all of the evidence. They don't even notify the children or serve them with any kind of notice, let alone get representation, let alone commission reports, and the kind of expert reports that, as Rudy identified, from independent social workers most often, which are the kind that you really need in order to succeed. And that was a case, the question of whether there was a proactive duty on the Home Office was something that BID argued for in another case which I was involved in as an intervener in the Chiari and Bindlos case, where we're trying to argue that there was a proactive duty on the Home Office, and the court sidestepped that argument. They declined to hear it in the context there of out-of-country deportation appeals. And so that is, in my view, still something that we need to press for. But the current, as I said, the current authorities from the Court of Appeal, and there's a couple, HA Iraq, and then another one, KB Jamaica, that I was involved in, and AA Nigeria. Those cases at least have the beginnings of identifying that you can't just assume that somehow there's a degree of harshness that children can put up with, without saying that what Lord Justice Underhill said was, well, it's not, you can't say that there's a common or ordinary effects of deportation which isn't sufficient to meet the threshold. So he's sort of trying to work out what the KO Nigeria question was, and trying to put it in terms that allow for the best interest of the child to be properly evaluated. And there was a family court judge there in that case, Lord Justice Peter Jackson, who did a really important job by saying that it's important that the decision maker doesn't treat physical harm as intrinsically more significant than emotional harm. So so as Rudy identified, the Home Office decision letter will commonly say something like, there's no direct adverse impact on the child, or there's no particularly harsh impact. But what they're doing is forgetting that emotional impact on children, emotional harm caused by separation, is part of the test. And so how a child will be affected by the parent's deportation will depend on an invariable range of circumstances, and it's not possible to identify a baseline of ordinariness over which you then have to show something extra. And I think that is the building block for interpreting the law in a way that's compatible with the UN Convention on the Rights of the Child, the Section 55 duty on all the public authorities, the court and the Secretary of State, and allowing for a proper evaluation of rights. But that can only happen in practical terms, as Rudy mentioned, if you have access to legal representatives that are paid for by the state and you have the opportunity to access them. And so those are the things that are happening in practice. You have this sort of collective thinking that you can't win a deportation case. You've got some really important refinements of the law through the sort of higher courts. But in order to win those cases with those refinements of the law, and in the first set of representations you make to the Home Office, or in the first appeal that you have to the tribunal, you've got to have all your arguments marshalled, and you've got to be able to have the evidence. And that's obviously where things are going wrong, because if you're taken from prison to detention centres served with a deportation order, there's no opportunity for that to happen meaningfully. There's no opportunity for the social worker to evaluate the child's relationship with the parent whilst they're in the same place. And that, of course, is the thing that is going to be disrupted and or possibly ruptured either permanently, which is what happens in deportation cases of over 4 years, or for a minimum period of 10 years for people in the under 4-year category. In either scenario, 10 years is a lifetime to a child. And so the idea again that there's no real meaningful way in which the children can have their rights assessed or evaluated, let alone vindicated, is I think what is going wrong in the system. And so one of the things I have been trying to work on is trying to get children to bring their own human rights claims, because it's only then that the children can be seen as rights holders and have their rights evaluated. And I'm having a real tussle at the moment in various cases to try to get funding for children separate to the parents. And it's also the basis upon which we lodged an application to Strasbourg, which we hope may well be communicated in due course as a substantive case. But I understand that the Strasbourg court is about to hear, or certainly start the process, the ball rolling, for a series of cases on deportation, which may or may not assist. I mean, there's a political question as well, because there's a political unpopularity, of course, for criminal deportees. No one's going to rush to try to defend them in political terms, I think. And what's more important in terms of trying to achieve change is to say, well, the way forwards is to focus on the British children who have rights that have barely any consideration of, and barely, certainly procedurally, let alone substantively, no one's even listening to them, no one's asking them what they think. There's an obligation in the UNCRC to hear from the children, Article 12, but we don't, for children who are old enough to have their views considered, but we don't hear from those children. And sometimes you get maybe a letter from a parent or a letter from a school, but nobody is asking the children what they really think. And that again is where the impact on them, which is the permanent removal or separation, is really being downgraded into in the statutory appeal process. So I have a number of cases where, and including one of the Jamaica charter flight cases, where the father was about to be removed and he'd never brought an appeal, and the children there was no evidence at all from the Home Office before the Home Office about the children, because they'd never asked, apart from to say to Dad, you're being deported. So so we've managed to stop the dad's removal, and we're putting forward representations for the children. But that is a practical example of how close we came to the children having their father deported without any consideration of their own rights at all, let alone having an appeal and losing it, but just simply none. And that is not a state of affairs that we should tolerate in this country. Thank you. I think I've run out of time.
Sonali, thank you. And that was so strategic. So strategic, both legally, as one would expect, but politically too, in your little breadcrumbs in the forest. And the key is quite possibly to focus on these British children. Like all great ideas, it seems so simple once it's been shown to you. So thank you so much for that. And now for the final panelist, before we move into questions and discussion at about 5 o'clock, we have Dr. Melanie Griffiths from the University of Birmingham, and amongst other work, she is the author of Deportation and the Family. Sorry, Deportability and the Family. Even better, it's because it's a clever long word and I can't read my own handwriting. Forgive me, Dr. Griffiths. Let's hear from Melanie.
Brilliant, thank you. Thanks all of you. So I think we've heard some really powerful testimonies here, and as we're all aware, the UK's immigration system is getting ever bigger and more punitive and purposefully cruel. And we have ample evidence of the harms that an insecure immigration status, detention, deportation, etc. does to people. But what we're recognising increasingly is how much wider those ripples of an inhumane immigration system go. How one person's insecure immigration status harms all those around them. And reports from BID and myself being launched today look at how that harm is also done to British citizens. So people who are themselves not subject to immigration rules are suffering significant harm significant in its breadth and its depth, and that this harm is being done knowingly and deliberately by the government. We've heard about this unduly harsh threshold, which the government guidance calls excessive cruelty. And so today I'm going to summarise research that looks at how this expanding immigration system, and especially these changes to how Article 8 rights are interpreted, have created a category of family that is especially insecure, mistrusted and conditional, with British citizens caught up almost as collateral damage, so being punished almost for association with foreigners. Now, the research followed 30 families, almost all of whom were heterosexual, so they involved a foreign national man with some kind of insecure immigration status and their British partners. And in more than 2/3 of these couples had children together, all British. They were extremely diverse. So you had British partners who were on very low incomes, you had also homeowners and professionals, GP, university lecturers, who happened to be in relationships with foreign national men with huge diversity of nationalities, ethnicities, length of time in the UK, anywhere from 1 year to 30 years, and very diverse immigration situations. So you had men who were in the asylum system, who were on temporary visas, visit, student, spousal, who had overstayed visas, or who'd gone through the criminal justice system and faced deportation. So huge diversity of situations, but really shocking similarities in terms of experiences. And it's important to note that what I'm going to describe doesn't just affect people with criminal records or unlawful status, but also families with a family member who's got a lawful but time-limited visa, which most visas are. And the damage being done to these families were really on 4 grounds. Firstly, immigration battles themselves, be it visa, asylum, deportation, are very long, expensive, invasive and emotional journeys that take years and cost thousands. And as we've heard, there is very little legal aid now for people and ever fewer appealable decisions anyway. Secondly, the reality of life with a precarious immigration status, or living with somebody with a precarious immigration status, is one of chronic uncertainty. People can't imagine or plan their futures. They're stuck in limbo, really traumatizing levels of insecurity. And this can continue even after someone has a visa, so often temporary or probationary. And financially, life with somebody with an insecure status is very hard. Generally, people aren't allowed to work. They also can't claim benefits, and yet perversely may impact on the British citizens' benefits. Plus, immigration applications have very high and growing costs, non-refundable, and there's legal costs, so huge financial as well as emotional costs. Thirdly, it's very hard often to get your relationships believed or valued by the Home Office. So these couples have a lot of official scrutinising of their families. They're often seen as fictitious or opportunistic relationships, as an attempt to circumvent immigration controls, or seen as genuine but nonetheless sacrificial to public interest. So people end up in very long and incredibly intrusive battles, getting their relationships to be believed in the first place, let alone then valued. And it's worth noting that a lot of barriers to proving your active relationships and parenting are created by the Home Office and the immigration system itself. So if you're in immigration detention, if you're not allowed to work, it becomes very hard to prove yourself as a genuine and meaningful father, for example. And fourthly, the immigration system separates families in all sorts of ways, and all the couples faced the threat of losing a loved one, and about half experience some kind of immigration system related separation. And that can occur both within the UK, so immigration detention, but also asylum or bail addresses, and overseas, so people not being allowed into the country or being forced out, or having to go overseas to apply for out-of-country visas, which may take months or years. And these kind of separations are indefinite. They may be very long, they may be forever, but you don't know how long. And they can be repeat. Something like detention is often repeated. And we're not going to go into immigration detention much, but just to note that immigration detention is incredibly damaging to families, and these decisions to detain are not made with families in mind. People may be detained very far from families, transferred frequently, visits conditions and halls often aren't family friendly, and there is no policy in place to help parents in detention maintain contact with children, as opposed to prisons, for example. And indeed, it's not actually in the Home Office's interest to help maintain these relationships, because it would add to arguments for remaining in the country. So the impact, as you've heard from other speakers, is extreme, both in its breadth and its depth, and it's to the whole family. And it harms everybody in the project, but it harms some people more than others. So those who are already socially or economically marginalised are hit hardest. In terms of the British citizens, it affected their plans, their dreams, careers, finances, their physical health, their psychological well-being, their relationships, social mobility, feelings of national identity. Now, across the board, they're made poorer, sicker, and less happy because of the immigration battles of their loved ones. It damages relationships between partners, between parents and children. It affects marriage decisions, plans for starting or expanding families, possibilities of being a stay-at-home mum or being able to take up maternity leave. Financially, the families face extreme, in some cases, financial hardship. People lost savings, took out loans or debt. Some families had to resort to crisis loans, food banks. There were some families who were having to appeal on social media for baby milk. Several of the interviewees, the British interviewees, sold their possessions to try and help these immigration battles. And the workload on the British partners is often huge. As the only person who's allowed to work, they may take on excessive work hours or jobs to give up maternity leave, or even have to lose work to take over childcare if their partner is removed or detained. And as we've heard from Rudy and others, the impact on children is particularly severe. Although children are protected in domestic and international laws, their best interests are conditional, and their rights are affected by their parents' immigration status. The research found clear harm to their standard of living, education, and mental health. Children were developing emotional, developmental, and behavioural problems. We've heard about regression, bedwetting, school performance would suffer. Children were developing anxiety, depression, PTSD, nightmares, insomnia, a lot of attachment and abandonment issues. I would have interviews where the children would ring during it to make sure daddy was still not detained because he'd been detained so many times. And in some cases, especially some of the older children, were ending up self-harming. And to give you an example of quite how high this unduly harsh threshold has to be, in one case, a 13-year-old girl tried to attempt suicide because her father was facing removal, and that did not meet the unduly harsh threshold, either according to the Home Office or in tribunal. The separation to the children were particularly damaging. Some of the children had never lived with their fathers and only knew them through a screen, but most of the children had lived with their fathers and then experienced losing them. And the Home Office tends to present Skype and phone calls as equivalent to in-person fathering, ignoring all the emotional, developmental and practical barriers to that. But the research really clearly showed that parenting by Skype is not possible. And I think the pandemic has given us all a bit of insight into quite how inappropriate that is. And also, just to note, the Home Office in the case I saw tended to always assume that the mothers were the primary caregiver, and the father, especially if he was racialised or criminalised, was really quite superfluous to the family. And whilst that was never the case, it was particularly evident in a lot of these families, the father was actually the main primary caregiver because he wasn't allowed to work. He did most of the care work. So for these families, losing their father was actually particularly devastating. Now, these experiences shook the feelings of Britishness and belonging of the adults and children in these families. You know, not being able to resolve your partner's immigration problems, experiencing really high levels of state-sanctioned harm to yourself, your loved one, and especially your children, having your own government disbelieving you, judging you, not caring about your decisions, your families, and in particular having your own government advise you to leave the country if you'd like to continue living with your partner, which is something that a lot of the women were explicitly advised by the Home Office. This kind of treatment really affected the British citizens' trust in the state. They felt really betrayed and abandoned, rejected by the UK government, and like lesser citizens, like the British government really didn't want to care about them. And this affected their feelings of national identity and loyalty, with implications that some of the women were considering renouncing their citizenship, some left the UK in disgust. A couple actively were undermining UK border controls. And quite a few of the women started acting or feeling in ways much more reminiscent of precarious migrants than full citizens. So, for example, one woman lived with her suitcase packed at all times in case she had to leave. Others lie awake worrying about dawn raids from immigration officers in the morning. People freak out when they see immigration vans. One British woman would always carry her passport around in case of identification checks. And I think it's important to notice that the children also end up feeling less British and resentful of their governments. And several of the parents told me they really worry about the impact on their children as they become teenagers and adults, or the future implications of this. So just to finish, this kind of system affects everybody, but it affects some people more than others. And it's clear that there are biases to all of this. And we know the criminal justice system, but also the immigration system, the immigration detention, deportation, these all disproportionately affect Black and ethnic minorities. And we have discrimination woven into the immigration system with sort of racially biased visa categories and assumptions being made based on people's ethnicity and language and money as well. And so too, the evaluation of family life is really strongly shaped by ethnicity and gender and socio-economic status of both the foreign nationals and the British citizens. So although human rights are supposed to recognise about discrimination, you can see in the research biases to how families and relationships are being assessed as genuine and meaningful, and how they were valued and balanced against the public interest. The foreign national men were routinely facing suspicion over their motives, and their family ties were often seen as opportunistic or not valued. They were considered dispensable. Their physical presence in particular deemed non-essential to family life, be replaced with a virtual screen. And the British women felt very patronised, that they were seen as being as vulnerable and led by emotion, being fooled by foreign men. Their rationality, good character, parenting, national loyalty were all questioned. And I would argue that we're seeing here a modern continuation of historical unease over British subjects marrying beyond the nation, and historically much weaker and less secure citizenship rights of British women, alongside long-standing suspicion that foreign men are using marriage or children as a loophole. And this is historical unease and suspicion that's long had very gendered, racialised and classed undertones. And although today it's not so overtly biased along gender and race lines, it's still there. So until 1948, British women lost their nationality if they married a foreign man. Today, British women are no longer losing their nationality legally, but nonetheless, these citizens' full belonging is still weakened through relationship to a foreign national, and they're still having to make these decisions about whether to leave the UK if they want to be with their partner and the father of their children. Thank you.
Thank you so much, Melanie. Sorry, I was struggling to do my tech there. Thank you so much for that crystal clear and compelling presentation on impact. And I should say also, in thanking you, that that this event this afternoon is being co-hosted by the University of Birmingham. So imagine that weird time pre the pandemonium when we would actually be perhaps in a lecture theatre at the University of Birmingham, and we'd be sitting together that way, and imagine that, and we thank the Academy as always for that kind of support, which NGOs like BID need, as well as the research and that kind of support. So now we're going to move into the last part of the event. We've got about 25 minutes for questions and discussion. So what I'm going to do is to take the questions in groups and allow any panelist that wants to chip in as they like on any question or questions that they want to talk about. I'm beginning with a comment from Shona, which is very reminiscent of some of the points that Sonali was making in forensic depth. Shona says, on the rights of the child, speakers have spoken about the difficulties of obtaining evidence of harm to the child because of the lack of legal aid. But don't we think it's shocking to have to obtain specialist evidence to show that a child would suffer harm? Aren't we saying that any child would suffer harm if losing a parent? And then from Arania, do you think it would assist if once serving a parent with a deportation order, the Home Office were compelled to also serve a notice on the child, either as a party or an interested party? The child could then be represented in the proceedings. And thirdly, and this is from an anonymous friend in our meeting today. I'm feeling quite hopeless about all this at the moment. My main question is probably the same as that of many people. What about other family members? I'm an only child. My only family left in the country, this country where I was born, is my mum. Why can't my mum come and live with me in the UK unless she's in such dire conditions that she can't take care of herself? Why should that be the case? So those are the three initial questions. Please think of others and put them in the Q&A. Who would like to speak first? Maybe Rudy would like to come back.
Yeah, that'd be good. I mean, I'd like to address Shona's question most of all, really, because I think the way that Shona's asked it just really, throws into quite sharp relief just how disproportionate the system has become, and it is shocking that we have to, people have to go to great lengths to gather evidence of the harm caused to children, and at the same time trying to overcome obstacles to gathering that evidence, such as the detention system. But yeah, why should they need to be gathering that evidence in the first place? I think, that's why we wanted to carry out this research in a way, was just to show just how overwhelming the evidence is that, this is going to have such severe and long-term consequences on so many people, to the point that it's in no one's interest, and that shouldn't be a surprising, that's not a surprising finding from this type of research. That's just a common sense assumption. And so, yeah, that needs to be reflected in the system and in the legislation. And, from BID's point of view, we shouldn't be looking to deport parents, and the whole system has become wildly disproportionate. And yeah, I think, very much it just helps to show that what is a common sense assumption in almost every other aspect of policy and of life and of government is in the context of immigration, you have to, it's the opposite really. And it's not, yeah, the Home Office's approach is kind of like, it ignores that common sense perspective. Yeah.
Sonali?
Well, I just wanted to add, I totally agree. And one of the reasons that the case of KO Nigeria failed in the Supreme Court was because they said, well, there wasn't any expert evidence about the impact on the children, even though all the children had spoken about what would happen if the father was deported. And you know, astonishingly, in that case, one of the reasons the expert evidence was rejected was not before the court, was because it was rejected because it was served late. So you can see that there's a structural procedural problem where you're not hearing from the children. You're not. The only evidence that there was from the children, which we might say is the ordinary presumption. There should be perhaps a presumption that it's not in the best interests of children and that it is unduly harsh. And then maybe that's the way you can avoid having to get evidence, is by the introduction of presumption. That is something that Parliament might be able to live with or be interested in enacting, because it is again, it's not about foreign national criminals, which is what the sort of political difficulty is, but it is about presumption in respect of children.
And Melanie?
Yeah, just to add a little bit. The question of evidence came up so much, and it seemed to be one of those situations where you could never get enough, basically. If you didn't have evidence, then that worked against you. If you did have evidence, then it wasn't of the right kind, or it was late, or it wasn't enough. Or it never really seemed to matter. And in quite a few cases, the Home Office kind of completely ignored the fact that there were children. So even if you had letters from the kids saying, this is what's going to, this is how I feel about my dad being deported, the Home Office would then just write a letter that might just completely ignore the fact there were children anyway. I always wonder whether if deportation cases were heard not in the tribunal, but in mainstream, in the criminal courts or in courts with higher evidential requirements. So you weren't being able to rely on hearsay and some of the really unevidenced statements by some of the presenting authors, is whether that would be a higher level of protection that these families need. And just in terms of the family, very briefly, I say, yes, that's a whole other discussion, but family here is being interpreted in very narrow terms. And I have sat in some really heart-wrenching deportations where, you had refugee children, now young adults, and the young man was being deported, and the system flooded tears saying, this is my only family that is left, but it's a sibling, so it didn't really count. So yeah, there's a whole other discussion, but what counts as family is a huge issue here.
Thank you. So I've got some more questions here, and as we're into our last sort of 15 or 20 minutes, I'm going to again put a group for our panelists. So forgive me that I'm condensing quite a few questions in one. So Pierre says this: can Sonali please explain more about her thinking on making a human rights application on behalf of a child? Would that be an application to the Home Office and then an appeal? From Patricia, how do you think that Brexit may affect this deportation system, especially considering that now European families can also be excluded from pre-and settlement status, she says. From Smita, do the panel also think that criminal defence practitioners must be aware of the risk of deportation following convictions and sentencing? This is a great question. Should there be a greater overlap between their work and that of immigration lawyers? This would also cover those who are convicted and are victims of trafficking. That's a great question, Smita, because when I was listening to Sonali talk about the Charles Clarke moment and how that triggered a desire to join up, for greater joining up in the system between imprisonment and deportation, I'm thinking there needs to be some more joining up in response in terms of those who advocate for people's rights. And then from Marina, again for Sonali in particular, but I'm sure others will have things to say about this. Do you think that actually, sorry, I've already said that. So that was Marina was echoing Smita's question about the need for overlap. So that's clearly a very popular line of concern on this call. So So yes, who would like to go first this time? Perhaps Sonali.
Okay, thanks very much. So just coming back to try and answer Pierre's question. I mean, to me, this is a process point. The children are all Human Rights Act victims under Section 7 of the Human Rights Act. They are entitled to a meaningful remedy. The remedy is supposed to be in the appropriate court. So if the father is having a deportation appeal, you might say that, or a mother, the parent, you might say that that is in the tribunal. But it doesn't mean that they can't be separately represented. This goes back to something that happened sort of 2006. There was this, we had this attempt to do that in the old days, and then the House of Lords found that one family, one appeal, ordinarily the rights of the children would go with the parents. But we've moved, that was Bioku Bet's a case I did in the House of Lords in 2007, but we've moved a long way in statutory terms since then. And the evidence that Melanie and Rudy have been talking about identifies that children's rights are not being identified, let alone vindicated, through the appeals process. So I think in terms of that they should be applying for legal aid, which I'm doing for some of the kids I'm representing at the moment, and then having a massive battle with them about that, making a human rights claim to the Home Office and saying, I want you to treat it distinctly and discreetly from my parents' application. That's what's required by the law. And then I want a remedy. And if you don't say I've got a remedy, then I'll have to judicially review you, because that's the only place I can challenge it. If there's no other, I haven't got a right of appeal because I'm not the appellant.
So you're building a test case to the way that this process
I'm trying to
structured.
These two Jamaican, the Jamaican dad and his two kids who were about 24 hours from deportation with having never been near a court.
Great. And Melanie.
Hi, yes, I agree. I think there needs to be a lot more overlap between the criminal and immigration systems. It was really shocking sitting in on deportation appeals, quite how little knowledge of the two areas there were. People being represented by immigration barristers, if they were being represented at all, but people who didn't know about the criminal justice system at all. And where it's particularly shocking to me actually was in cases involving Operation Nexus, which is this really shadowy, little known cooperation between the police and the Home Office, in which somebody could be deported not based on having been convicted of a criminal, being convicted and gone through the courts of a criminal act, but based potentially on their police file. So things like just having had enough police contact and being stopped and searched, 100 times, even if nothing is ever found. You get this kind of big police file with sort of just all sorts of circumstantial, not very serious kind of ASPOs and having cannabis on you or something that never goes before a court. And on the basis of this, then people can be deported through Operation Nexus as a potential foreign criminal. And there you really saw the impact of not having somebody who knew anything about the criminal justice system and how the police worked and how to challenge these things. And then anyway, because it was going through the tribunal with such different evidential requirements, kind of hearsay and all these little bits of, somebody said they saw you, and the fact that they said they had an Irish accent and he got a Jamaican accent. We don't worry about those kind of details. And some of these kind of really shocking little bits we're getting away with because people didn't have the kind of expert joined up legal representation that they really desperately need in these kind of cases.
Do I find it astonishing that there are people in this country who still don't believe in structural racism. But there you go. I'm astonished. It's possible to be astonished and not surprised, isn't it? Rudy.
Yeah, just following on from that, I think it's a great question, and I just also what Melanie said about Operation Nexus cases. It really is quite staggering reading about some of these cases and the types of evidence that is used and the way that the Home Office builds a picture of someone's character on these often incredibly racist assumptions. And I would encourage people to find out more about that because it is something that a lot of people don't know very much about. But in terms of the issue of there needing to be more of an understanding of the immigration system and deportation law among criminal solicitors, I think that's really important, particularly as, from our point of view, we encounter a lot of people who are detained in prisons and have no access to immigration advice whatsoever, and the only support they've often had is is through the duty solicitor they had when they were convicted. And it's really difficult then about once they're in prison to get any kind of immigration advice, and it would just help a lot if there was more understanding of that from the criminal solicitor. Yeah. And also the issue that the person who asked the question raised about this being a big issue in trafficking cases, we see that as well. So there's a lot of people who we encounter who are in detention centres or prisons, and they've been through the whole system of they've been trafficked and then been encountered by the authorities, and they've been tried, convicted and sentenced and then imprisoned and then detained under immigration powers, and at no point along the way has anyone identified that they quite clearly could be a victim of trafficking, and that would have a bearing on their immigration case. But there's a lot of people who could have identified that, and a lot of that is the responsibility of the authorities, but there is also an issue with criminal solicitors not having an understanding of that. I also did just want to briefly touch on the question about Brexit, because we didn't, our research is specifically focused on deportation, and it's about the legislative framework for non-EEA nationals. EU nationals are now going to come under that same system after Brexit. It will depend on when they committed an offence, but currently, as it stands, EU nationals are meant to have much greater protections from deportation. I think it's that the Home Office needs to show that they're a threat to public policy, public security, or public health, and so that is seemingly quite a much higher protection. And I think, well, I'm not aware of the numbers, but I think it's easier to win an EU deportation case. But at the same time, we encounter a lot of people in detention who are deemed by the Home Office to be a threat to public policy, security, or health, and are given a deportation order. But in actual fact, they've just committed a string of really minor offences. In some cases, not even received custodial sentences for those criminal offences. So, EU nationals are already subject to quite a harsh deportation system of their own, even though the way it is written in law, it would seem like they should have greater protections. But yeah, pretty soon they're just going to be in the same pot as everyone else.
Thanks for that, Rudy. We've got a few more minutes, and there was this wonderful question from one of our friends on the meeting, which is, are there any signs of improvement in the immigration system on the horizon? So that's a final question. And if not, I'm going to add and say, if not from the system itself, if not from the kindness of Priti Patel's heart, are there signs from the courts or from any other source? Who would like to go first on that? Maybe Melanie.
Hi. Yes. So politically, I don't feel very hopeful. We're going ever further and down a very horrible line. But I am just beginning to get hopeful about the more general public and the media beginning to think maybe this has gone too far now. And part of what gives me hope is that these kind of little stirrings of concern from lots of different areas. So Windrush obviously really brought a lot of this to light, but we're also seeing around the charter flights, people feeling quite disturbed. Hostile environment now is also highlighting how wide these kind of systems go. We've also got the spousal visa, and there's incredibly high minimum income threshold that citizens have to earn before they can bring in a spouse. And we've got EEA nationals now also being detained and removed. And so we've kind of got all these different areas in which people are beginning to say, wait a second, this isn't quite what I thought was going on. And I'm just beginning to be hopeful that that in itself will start eventually to turn the political tide. So if we'll start writing to our MPs and saying, actually, this is not what we thought was going on in the immigration system, then maybe there's beginning to be enough of a broader groundswell that we can be hopeful going forwards.
Let's hope, and let's work towards that end as well with meetings like this and the kind of mobilisation and and strategy that we've heard all of you talking about. Rudy, what would you like to say by way of hope?
I think it is important to try and remain hopeful throughout, working in this area, and it can be demoralising seeing, the proposals that the government is currently coming out with, particularly in relation to asylum. But I think Melanie's right that there is like a lot of mobilisation from a lot of different sources, maybe more than there's been before, and there's kind of whether that's direct action groups or campaigning groups, or and more conversations in Parliament. I think there's a lot of different sources of people coming out and like expressing sympathy for migrants, and there's kind of been a reaction, I think, to the government's intention to base a lot of its policies on being as harsh as it possibly can to migrants. And I think I don't know, you have to cling to like the really encouraging examples of collective action. And I think things like what happened in Glasgow a few weeks ago, where a spontaneous protest kind of stopped an immigration raid from taking two men away on Eid, at celebration. I think that was such a beautiful example of what can happen when people come together in collective action. And I think also, maybe Sonali can talk about this more, but there are a lot of positive developments in the courts, and some of the kind of particularly harsh things that the government has done recently. So, for instance, in relation to holding people in military barracks, recently found to be unlawful. And I think, the government is coming under pressure from a lot of different sources, basically.
Thank you, Rudy. And yes, the Napier Barracks case, which Sonali was also involved in. So Sonali, we come to our Silk for the final word, and a word of hope, please.
Well, yes, I just should say I had a relatively small part in that intervention for JCWI, but it was important to tell the court that people had never been detained in this way, in such conditions before. And it was absolutely appalling. I'll say the final words I will say is the title of the seminar I last did on deportation in children was called Reasons to be Cheerful, with a nod to Ian Dury and the blockheads. And the reason it was because of that case of H.A. Iraq in the Court of Appeal, where the family judge start to make his mark by saying this is what it really means. Now, there have been different cases before and since that, which have gone either way. But there are reasons to be cheerful, but in the sense of the law, but you've got to be able to get the law to work for you. And that comes back to the points we talked about before. So largely not, but I will say we did say reasons to be cheerful only on the 8th of February when we wrote our last seminar. So that's what I'll say.
Well, thank you so much for that. And, as always, solidarity is the destination, but it's also the means of transport. And for my own part, it's been an absolute privilege to listen to you all, let alone to chair this event today for the University of Birmingham and BID. So thank you so much, panelists, but thanks also to everybody who came on the call today and engaged and put their points and questions. This is such important work on behalf of some of the most vulnerable and long demonized members of our society, because that's who they are, whether they committed a criminal offence or whether they are the child or loved one of someone who did or didn't, in the case of soft information and miscarriages of justice and everything else that goes into that pot. So thank you, BID, thank you, Birmingham, thank you, Melanie and Rudy and Sonali. Thanks everyone, and stay safe.